The following is for trained court personnel. Do not try any of this at home.
Ever.
In this very special episode of Mythbreakers, the team will be looking at Chapter 39 Injunctions. First, Addie and Jeffrey take on the myth that attempting to do a Chapter 39 injunction will make the case files spontaneously combust. Then Katie and Brant put the protection in protective order. Just who are the Mythbreakers? Addie Salvage. Jeffrey Himmerman. Between them, more than 10 years' experience in court analysis and shrinking tall tales down to size. They're joined by Katie Boron and Brant Howrowitz. They don't just analyze the myths, they break them down. The first myth on the docket is the myth Up in Flames.
So who brought the petition here today?
I did, Your Honor. I'm from DCF and I filed this on behalf of Johnny.
But you're not the victim. You're not even the child's parent. There's a protective investigation, but no dependency petition. What are we doing here today? Whoa! Whoa!
Something tells me we're not going to be doing myths about pirates today.
No. Today, we're talking Chapter 39 Injunctions. All our myths today come from judges in Florida. According to them, Chapter 39 injunctions are a lot of trouble.
And really hot to handle.
Our first myth is that Chapter 39 injunctions are so complicated, every time a judge tries to do one, the case files explode into flames.
We don't want that.
No, we definitely don't want that.
So how do we test this myth?
Well, I think if we want to do this right, we should get some information about Chapter 39 injunctions, then we should test it out by simulating a judge doing a hearing using the Chapter 39 injunction process.
And hope the case files don't go up in smoke.
With the plan in mind, Addie and Jeffrey go to a courthouse to talk to the experts about this volatile myth. The team sits down with Robert Know-It-All, a self-proclaimed authority on Chapter 39 injunctions.
So, how difficult is the Chapter 39 injunction process?
No, not difficult at all.
Have you ever seen or heard about anyone's case files bursting into flame when they tried to do a Chapter 39 injunction?
I've never heard of that.
So if Chapter 39 injunctions don't make case files burst into flames, how are they different from Chapter 741 injunctions?
There's a lot of little differences, but mainly in a Chapter 741 injunction, the goal is protecting the victim, whereas in a Chapter 39 injunction, the goal is protecting the child from harm or abuse. In a Chapter 741 injunction, the petitioner is going to be the victim, but in a Chapter 39 injunction, the petitioner may be the victim or may be someone else, such as the department. And then finally, in a Chapter 39 injunction, the respondent need not be a parent, be related, or even reside in the home.
Sounds pretty simple. So what about Chapter 39 injunctions puts the case files in the hot spot?
So the Chapter 39 injunction process, it's based in Florida law?
Yes, Florida Statute Section 39.504 says, law enforcement, state attorney, Department of Children and Families, the court, or any responsible person can petition for a Chapter 39 injunction anytime. And jurisdiction attaches when the petition is filed.
Usually the Department of Children and Families will file the petition for a Chapter 39 injunction on behalf of the child. The non-offending parent or custodian doesn't need to ask for or even want the petition. If, through the Child Protective Investigation, DCF has cause to believe the child might be exposed and harmed by abuse, DCF can, of its own volition, petition for a Chapter 39 injunction.
A judge may enter a temporary injunction if he or she feels it's necessary to protect the child. Then both the offending and non-offending parents or custodians are served with the petition and notice of the hearing, which should be held at the earliest possible time.
If the judge believes the child is in imminent danger, but the court is closed for the transaction of judicial business, the judge may issue an immediate injunction without notice. If the judge does enter an immediate order, the court must hold a hearing on the next judicial business day to dissolve, modify, or continue the injunction.
At the injunction hearing, several parties are usually present. the offending parent or custodian and non-offending parent or custodian, attorneys for each parent, guardian ad litem to represent the child's interests, child legal services attorney or attorney general attorney, and possibly a case manager depending on the particular case. Other relatives or caretakers may also be present. If the judge feels sufficient evidence has been presented in support of an injunction, he or she can issue an injunction.
Right. And remember, the primary purpose of a Chapter 39 injunction is to protect and promote the best interests of the child and take into consideration the preservation of the child's immediate family.
Chapter 39 injunctions should be granted only if there's a reasonable cause. Reasonable cause exists when there's evidence of abuse or a reasonable likelihood that abuse will occur. And reasonable likelihood is based on recent overt acts or failures to act.
And Chapter 39 injunctions are effective until modified or dissolved by the court.
With their facts straight, Addie and Jeffrey start preparing a trial by fire. Meanwhile, Katie and Brant are back in the lab.
So, Addie and Jeffrey got combustible paperwork. What do we get? Car chases in judges' robes?
Not this time. We get to tackle some serious myths. These myths can't really be tested, but there's a lot of misinformation that we've been hearing that we can dispel right now.
Sounds good. What do we have lined up?
Well, our first two myths are tied together. The first one is that if there's abuse, the non-abusive parent or custodian has to leave or has to do something to protect the child or children. And the second one is that a Chapter 39 injunction can't protect adult victims and puts them in even greater danger.
I know that adult victims often believe that they can't leave the abuser. They don't have anywhere to go, they don't have enough money to leave, or are dependent on the abuser, or they just don't feel safe leaving. After all, 74% of women murdered by their partners are murdered during or soon after leaving them. One benefit to a Chapter 39 injunction is that it can be used by someone other than the non-abusive parent to protect the child or children.
Right. And we know that because the injunction petition may be filed by DCF and not the adult victim. The adult victim may be less likely to become a target for the batterer. He or she can rightfully claim to be an innocent bystander in the injunction process and deflect a lot of the batterer's anger away from herself or himself.
So we can break those two myths right now. What else?
Well, the third myth is that in order to get a Chapter 39 injunction, the child has to be the victim of the abuse.
I've heard that one before, but that's not necessarily true. Child abuse is a term that can cover many different kinds of activity. Child abuse can be physical, emotional, or psychological. If a parent or custodian is the victim of abuse and the child is harmed in any way or is at risk of being harmed, it could be child abuse.
Exactly. The last one isn't really a myth at all. It's an overlooked fact that domestic violence has a horrible impact on children who are exposed to it.
Right. We wanted to talk about ways in which battering affects children.
The reality is that if domestic violence is present in a household, the children will know about it and will suffer because of it.
The batterer can abuse a child in much the same way he or she abuses the other partner in the relationship. Targeted children can be physically abused, threatened or humiliated, abandoned, or excessively punished for normal interactions. And children often become unintended victims when they try to intervene to protect the adult victim.
The batterer can also use treatment or threatened treatment of the child to manipulate and emotionally or psychologically abuse the other parent or custodian and affect the child indirectly. The child might not be physically harmed, but the effect is still there. The batterer can do any number of things, including denial of interaction between the adult victim and the child, threatened violence to the child, threats about taking the child away, actively setting the child against the other parent, destroying the child's possessions, or even abusing the child in front of the parent, who is often too terrified to intervene.
And the effects of abuse can be long-lasting. Children can have physical problems like headaches or ulcers, psychological problems like trouble sleeping, anxiety, nightmares, depression, or low self-esteem, and social problems like aggression or difficulty making friends. Exposure to domestic violence can even negatively affect brain development.
These myths were serious business, all right.
But by spreading the truth, we can break them just as effectively as if we tested them.
Yes, these myths are all broken.
Broken.
Addie and Jeffrey are finally ready to test their myth.
Well, we were able to find some space at a Florida courthouse to test our myth.
We got volunteers to play the roles of parents, attorneys, and professionals for the hearing.
And we found a real judge brave enough to dive headlong into this myth.
Judge Masterson, how are you feeling?
Pretty good, thank you.
Have you ever heard of this myth?
At every judicial conference I attend.
Do you believe it?
I think it's a bit of a stretch.
Well, are you ready to test it?
Yeah, let's give it a try.
Now, for this test to work, we're going to have to simulate an actual hearing.
Yeah, but actual hearings can vary in length. Some uncontested hearings can be quick, but contested hearings might take a while.
A real Chapter 39 injunction can take a long time if there are difficult issues, and the guys don't have much film left. So the judge will simulate a Chapter 39 process with the attorneys advising the court what evidence they'll present, and we'll just show the critical parts, like when the case files become too hot to handle.
Would everyone please start by stating your name and your relationship to the child?
My name is Ryan Schlesinger. I'm a DCF attorney. We filed this petition on behalf of the child, Johnny.
My name is Missy Jones, and I'm the case manager assigned to work with Johnny and the family.
My name is Bernadette Salsi. I'm here today representing Johnny's father, Aaron Jones.
My name is Albert Dewey, and I represent Diamond Jones, Johnny's mother.
I'm Riley Simmons. I'm a volunteer guardian ad litem, and I'm here representing Johnny's best interests.
All right, it says that DCF filed this petition. Why is that?
A child protective investigation was initiated as a result of a domestic disturbance incident. The police were called, and upon arriving on the scene, saw evidence of violence to the child and called us to evaluate the situation. In the course of our investigation, we determined that the child was a victim of abuse and was in danger of further physical harm. So we filed this petition.
All right, well, since DCF filed this petition, they'll get an opportunity to present testimony and evidence first. Every attorney is going to have an opportunity to question witnesses. If a party wants to testify or present a relevant witness, they'll have an opportunity to do so. All right? DCF, you may begin.
As I said, this began with a domestic disturbance at the home at about 8 p.m. The police were called. When they arrived at the home, Mrs. Jones and Johnny both had bruises on their cheeks and arms. Mr. Jones was drunk and was talking loudly in the living room. The police contacted DCF and told us that they suspected child abuse based on the bruising to the child. We initiated a child protective investigation. After interviewing Johnny, Mrs. Jones, and neighbors, we determined that Mr. Jones struck Johnny and caused a bruise to his cheek. Due to concerns about Johnny's safety, we filed this petition for an injunction.
Now that you've seen how a Chapter 39 injunction is initiated, let's fast forward a bit.
I've heard from all the parties today, and based on the testimony I've received, I find there is reasonable cause to believe that Mr. Jones did in fact abuse Johnny in this case. As a result, DCF has met their burden of proof, and I am going to grant this petition. Leaving Johnny in the home with Mr. Jones places him in danger of further violence. While I'd like to preserve this immediate family unit, I can't find that to be in the child's best interests right now until I know that Mr. Jones is not a threat. How would you suggest the contact order be written, DCF?
Based on our investigation, we think that no contact and stay away provisions are the best for the time being. If those are in place, we'd feel comfortable returning the child to the care of Mrs. Jones.
Well, I'm ordering Mr. Jones to vacate the home immediately. Mr. Jones, you'll have someone from the sheriff's office accompany you to your home today to gather your possessions. You may have no contact with Johnny, directly or through others, not at the house, at the school, anywhere else that he goes. Mrs. Jones does not have the authority to invite you over to the house either to see her. If you both want to meet in person, it has to be somewhere other than the home, and it can't be in Johnny's presence. Further, I'm ordering you to complete a batterer intervention program and have a substance abuse evaluation. Once those are successfully completed and services are in place to ensure Johnny's safety, you can petition to modify or dismiss this injunction.
Your Honor, what if Mr. Jones violates the injunction? How are we going to make sure that Johnny is kept safe and adequately protected by the injunction?
Well, if Mr. Jones violates the injunction, let's say he attempts to contact Johnny, Mrs. Jones, Johnny's teacher, principal, or any responsible person present can contact the authorities on his behalf. Law enforcement has the specific power to arrest if there's a violation of this injunction, and a violation is a first-degree misdemeanor. Remember, though, that this injunction is designed to protect Johnny, and so the provisions apply only to him. If Mrs. Jones feels that she is in danger, she would need to file for a protective injunction for herself individually, in which case she can file for a domestic violence injunction.
Looks like this myth isn't as hot as the guys heard.
So how do we wrap this up?
I'd say totally broken. We had a judge do a Chapter 39 injunction hearing and didn't see any fire. I don't think we could have asked for a more conclusive result.
Yeah, no flames here.